As of the latest update from August 2026, law enforcement agencies across the nation are expanding their reliance on advanced roadside interrogation tactics during routine nighttime vehicle stops. When an officer steps up to your driver's window late on a weekend evening, an invisible clock instantly starts ticking inside their mind. You safely lower your window, present your driver's license alongside your vehicle registration and proof of insurance, and prepare for what appears to be a standard procedure. That is when the officer leans in slightly, offers a polite nod, and casually asks where you are driving tonight. To almost every motorist, this inquiry sounds like polite conversational small talk designed to make the interaction feel relaxed and routine. In reality, your immediate verbal response triggers a highly calculated tactical interrogation technique known throughout law enforcement academies as destination mapping. Most drivers make a critical mistake during these brief roadside interactions by blurting out a quick, casual response without a second thought, operating under the mistaken belief that total openness will speed up the process and earn them goodwill. What these motorists fail to realize is that destination mapping is structured specifically to transform an unverified casual statement into concrete, legally binding evidence. The moment a driver names a specific intended location, the investigating officer immediately cross-references that statement against multiple distinct data points visible right in front of them, including your cardinal direction of travel, local highway layouts, active road construction detours, and the physical residential address printed on your state identification card. This rapid cross-referencing process gives rise to what police officers document in official written incident reports as a route inconsistency. If a motorist states they are heading directly home, but happens to be traveling eastbound on a secondary road because of an unannounced construction detour or a quick stop at a neighborhood gas station, the officer instantly logs that directional discrepancy. That single observation written in an official report stating the driver's claimed destination was inconsistent with their observed trajectory becomes the primary justification to escalate a routine 5-minute vehicle stop for a broken taillight into a comprehensive, multi-hour DWI investigation. In the officer's written narrative, taking a minor detour or driving down an unexpected corridor is reframed not as an innocent navigational choice, but as strong circumstantial evidence of severe disorientation, chemical impairment, or active deception. To make matters worse, this initial inquiry regarding your destination is almost never asked in isolation. It is almost universally paired with an immediate follow-up questioning what specific location the motorist is traveling from. By securing both the starting point and the intended endpoint of a journey, the officer effectively constructs an invisible geographic grid over your entire trip. With both coordinates established, the officer microanalyzes every single commercial establishment, late-night entertainment district, or residential corridor sitting between those 2 points. If the path intersects even remotely near a strip of local taverns, a late-night diner serving alcohol, or an area designated by local task forces as a high-crime district, the line of questioning shifts instantly toward probing whether the driver has consumed any alcoholic beverages or illegal substances, even when a driver tells the absolute truth regarding their origin and destination. They frequently walk straight into a secondary tactical trap known as timeline discrepancy. Law enforcement cruisers equipped with automated license plate readers, commonly known as ALPR technology, alongside localized dispatch logging systems, track exact timestamped records of when a vehicle passed specific intersections or patrol cars earlier in the night. If an officer notes that a vehicle was scanned near a specific thoroughfare an hour prior, but the driver states they only left their starting location 15 minutes ago, that unaccounted gap in time is instantly characterized as suspicious delay. Rather than attributing those missing minutes to idling in a parking lot to send a text message, checking directions, or waiting at a slow drive-through window, the officer documents the time gap as potential stops at drinking establishments or evidence of impaired time perception. Simultaneously, while these targeted questions are being posed, the officer is executing an intensive visual evaluation known as a behavioral scan. During this phase, the actual verbal words spoken by the driver often matter far less than their involuntary physical and neurological responses during the critical 3-second window following the question. Police academies train officers to meticulously observe micro-expressions, subtle changes in vocal pitch, slight pupil dilations, involuntary facial touches, or brief hesitations before speaking. In a standardized police incident report, a completely normal human reaction, such as pausing for a brief second to carefully formulate an accurate sentence under high stress, is routinely translated into formal legal jargon as indicators of deception consistent with active criminal concealment or physical impairment. Understanding the legal framework surrounding traffic stops reveals that citizens hold robust constitutional protections during these roadside encounters. Under fundamental Fourth Amendment jurisprudence, a driver is strictly obligated to present essential regulatory documentation upon request, which includes valid state identification, official vehicle registration, and active proof of financial responsibility. However, a motorist is under no legal obligation to disclose their private travel itineraries, personal background details, daily schedules, or personal origins. The landmark decision by the Supreme Court of the United States in Berkmer v. McCarty firmly established that drivers retain their core Fifth Amendment privilege against self-incrimination during routine roadside detentions. Furthermore, the legal boundaries governing how long an officer can delay a motorist were definitively drawn by the Supreme Court of the United States in Rodriguez v. United States. The landmark ruling declared that law enforcement officers cannot unlawfully extend the duration of an otherwise completed traffic stop beyond the time reasonably required to address the initial traffic infraction that justified the stop in the first place. This means that if an officer pulled a vehicle over for a minor speeding violation, they cannot hold the driver roadside to conduct an open-ended questioning session or wait for specialized units without independent, articulable suspicion of an ongoing crime. Crucially, under federal constitutional law, a citizen's peaceful decision to exercise their right to remain silent can never be weaponized by law enforcement as the sole basis for establishing reasonable suspicion or probable cause. To effectively navigate this high-stress interaction while maintaining complete legal protection and an undeniable record of compliance, drivers can utilize a precise three-part response script. When an officer asks about your destination or origin, state clearly, "Officer, here's my license, registration, and proof of insurance. I am respectfully exercising my constitutional right to remain silent, and I will not be answering any additional questions. Am I free to leave or am I being detained?" By physically handing over the required legal documentation first, you immediately eliminate any legal basis for the officer to claim you were being non-compliant, disorderly, or obstructionist under state vehicle codes. Following up that compliance with a clear, unambiguous invocation of your right to remain silent ensures that your refusal to engage in conversational questioning cannot be misrepresented later in a courtroom. Finally, asking the direct legal question of whether you are free to leave places the legal burden back onto the officer. Under the precedent set in Rodriguez v. United States, the officer must now either issue the standard traffic citation or warning and conclude the stop, or explicitly state the specific legal grounds for detaining you further. If the officer attempts to push back by using a classic interrogation tactic known as the guilt inference prompt, asking statements like, "If you have nothing to hide, why won't you answer simple questions?" simply remain calm and restate, "I am not trying to be difficult, officer. I am simply standing on my constitutional rights. Am I free to go?" Standing firm on these legal protections prevents law enforcement from building a case out of thin air, ensuring a routine drive home remains just that. That's it for today, folks. See you in the next video.